is Koslo again. It's Salamatu, and today we are going to be talking about how to brief cases. Simple as it may sound to us law students, we know that sometimes it's not easy. Sometimes you pick up a case and you don't even know what you are doing with a case. You don't know what to look at because it looks plenty to you. So today we are going to talk about 5 simple tips on how to brief cases that works. Listen, it worked for me all the time and I still use it till today. And it works. Before we delve into the tips, let's talk about the parts of a case. Okay. Now if you take any particular case, you can divide it into 3 or 4 parts depending on whether or not the case has been reported. And we say a case has been reported if it is found in a law report. This concept of law reporting was especially important in pre-internet ages because back then when the case happens or when a case has gone to court, you wouldn't know about it until it has been reported, okay? And the report was just a book, so to speak, which contains the cases. The only difference between cases that have been reported and the ones that have not been reported is that cases that have been reported come with head notes. And head notes are simply a summary made by the person who reported the case. Okay, so let's say like a newspaper, but it contains only cases. You get it? And it's more of like a booklet rather than a newspaper, right? So a reported case will have the head notes, it will have the facts, it will have the holding, and then it will have the reasoning. So those are the 4 parts of a reported case. If the case is unreported, it doesn't have head notes, okay? So it still has the facts, the holding, and the reasoning. The head notes, like I said, is the summary, which will be present if it is a reported case. The facts is the story that the people brought to court. So what did the defendant say? What did the plaintiff say? What did the respondent say? What did the applicant say? What did the petitioner say? What did the respondent say? Those constitute the facts of the case. Out of these facts, out of this story will come issues. These are the parts of the facts that the parties have not agreed on. Plaintiff is saying A, defendant is saying B, so they don't agree. So in any story, you would find that there are parts where they actually agree on. Those ones are not in issue. But the facts that are in issue are the facts that they disagree on. So let's say it's a contract agreement and plaintiff is saying he paid 10,000 cedis. Defendant is saying no, you paid 5,000. You even add 5,000 to it. So that part where the parties are disputing will result in what we call the issues of the case. Okay. Now, the holding is the answer the judge gave to each issue. So the issue is framed as whether or not the plaintiff gave the defendant 10,000 cedis. And then the judge would answer, yes, the plaintiff gave the defendant 10,000 cedis. That is, I'm just trying to make everything as practical as possible. Okay, so I'm just pardon some of my examples. So that is what the judge will say. The judge's answer is what we call the holding, and it would usually not be as short as I've tried to make it look, but the judge's answer is the holding. The reasoning is why the judge gave the answer he gave. In Latin, it's called the ratio. Okay, people say ratio decidendi or ratio decidendi, it's all the same. The ratio or the reasoning is why the judge gave the answer he gave. The wisdom behind the judge's holding is what we call the reasoning. So if it's an unreported case, you would have the facts, you would have the holding, and then you would have the reasoning. Okay, so these are the parts of a case. Now, having said that, let's now go and look at the specific tips that would help us to brief a case. The first rule is to ensure that you are relaxed. Yes, you heard that right. You must ensure that you are relaxed. So you see, you are about to read something that you need to process, and then you need to understand it, and then you have to remember it. That's a lot of work your brain is going to do. So if you are not relaxed already before you pick up the case, you may just read the first 4 or 5 sentences and you're lost, especially if the case is quite complex. If you're reading one of those tough constitutional law cases, and already your brain is tired, you are shortchanging yourself. So the first thing you should do is to ensure that you are relaxed. It should be perhaps after you've taken a break, and then you're going to sit behind your desk and then start reading it. If you're like me, I'll always have a cup of tea by my side just so I can sip while I'm trying to make sense of the case. So ensure that you are relaxed so that your brain is actually ready to process whatever it is that you are going to read. Secondly, don't start by writing. Don't write. Don't start by writing. What are you writing? You don't know what the case is about, but you are writing. You see, sometimes that's a problem. We know that we are supposed to brief the case, we are supposed to summarize the case, okay? So the moment we read one sentence, we are tempted to put it down because it sounds important or it looks important to us. But remember that you don't know the case. Even if the lecturer has explained the case to you in class, you yourself don't know the case. So again, what are you writing? You need to first ensure that you have read and gotten to a point where you have understood where the case is coming from and possibly where it is headed before you start writing. So don't start by writing. You don't know about the case yet. And I get it. There is that temptation sometimes because you want to feel like you're doing something. If you're sitting behind a book or if you're sitting behind the case, you want to start writing so that you feel like you're doing something. But no, the aim is to brief the case. And briefing simply has to do with reading the case, understanding what it's about, and reducing it into writing. So again, I ask you, you've not read the case, you don't understand what the case is about, what are you writing? So don't start by writing. Now, the first thing you want to do is to know what principle you are looking for in the case. Why are you reading the case? There are so many cases that you probably never read, even long after you finish your LLB and have gone to law school and you are done. There are so many cases you probably never even come across, okay? So this one case that you are sitting behind, why are you reading it? Let me give you what the usual case may be. You have gone for lectures and your lecturer has referred you to the case. The lecturer has referred you to a case in relation to a certain principle that she mentioned in class. And so if you are talking about vicarious liability and your lecturer tells you to go and read the case of Henrietta Bedu Enum versus Kafi Mining Company and Geoffrey Bedu Enum, the reason why the lecturer asked you to go and read the case is because that case discusses the principle of vicarious liability. And so that is the reason why you've come to sit behind your desktop, or you've come to sit behind your laptop, or you've even gone for your law reports to read that case, okay? So always ask yourself, why am I reading this case? What is the principle I'm looking for? In this case, the lecturer referred to the case in class, and she referred to it in relation to the principle of vicarious liability. So when you pick the case, you are concerned about how the case relates to the principle of vicarious liability. There are so many other things that may have been discussed in that case. Probably there is an issue relating to contract. There is an issue relating to negligence. You are not concerned with those things at that particular point in time. Your concern is the principle of vicarious liability. Okay. So always ask yourself, why am I reading this case? Why did the lecturer refer to this case for us to go and read? Right. So the third one, as I said, is that you should know the reason why you are reading the case, the principle in respect of which you are reading the case. The next thing, or the next point, which is the point 4, is that you must read the case in accordance to that principle. Sometimes the case is so sweet, quote and unquote, that you are likely to get carried away by some other thing, okay? But remember, we are racing against time. If you sit down for 3 hours and you are going to study for 3 hours, you don't have time to waste on things that are not important presently. So you want to focus on the things that are important. So you already know the principle in respect of which you are reading the case. The next thing to do is to ensure that you read everything about the case in respect of that particular principle. So at the back of your mind, if you read any facts, or if you read any sentence, even any single sentence that you read that does not necessarily connect to the principle you are reading the case in relation to, should not be given too much importance. Okay. Another time when you come back to read the case in relation to another principle, you do the same thing. So the fact that seemed important now will not be important that other time. As you read through and you keep noting the sentences and the statements that are necessary to your principle, you have to ensure that you are taking note of what is the fact, what is the holding, and what is the reasoning. Now, sometimes when you are lucky, there is a specific issue that relates to the principle you are reading the case in relation to. And depending on how the judge writes or the writing style that the judgment adopts, you could search that issue in the case and then go straight to it and read it. And I do it all the time. So I don't have to necessarily read the entire case, a 10-page case or a 15-page case, looking for a 5-worded sentence that relates to my principle or the principle in respect of which I'm reading the case. But if not, once you are going through the case and you are noting the sentences and you are noting the parts of the reasoning and the holding that relates to your case, once you get to a point where you found the answer you are looking for example, you are reading the case of Mensima versus Attorney General, and you know that is a case that affirms the supremacy of the Constitution. So, say the lecturer says in class that you should read Mensima versus Attorney General as a case that affirms the principle of constitutionalism or the principle of supremacy of the Constitution. And so you start reading the case. That is a case that has been reported. So you start reading the case, you read the head notes, you go down, you start reading the facts, you start going down, and you realize you've gotten to the point where the judge has made a pronouncement that any legislation that goes contrary to a constitutional provision is now void and of no legal effect because the Constitution is the supreme law of the land. Bingo, you've gotten to the point that you wanted to get to. Then there is no point to go down to read the entire case. Okay, so that is why I was saying that you must have the principle at the back of your mind, so that if you meet any sentence or if you meet any statement that answers the principle or answers to the principle or serves as an authority to the principle, this is very important. The reason why you are reading the case is because you want to use that case as an authority for the principle. In exams, if you go and write that the Constitution is supreme or the Constitution is the supreme law of the land, as a result of which any law that goes contrary to it is null and void, you will get only 1 mark. You would have to find a case that supports what you are saying. And that is the reason why you are reading the case that supports it, or that's the reason why the lecturer referred you to that case. It is so that in your exams or in future when you are arguing with the law, you can use that case as an authority to back that principle. So once you get to a sentence in the case, or you get to a statement in the case that backs the principle, bingo, you've reached the destination. You've gotten to that is the entire essence. You are done. Okay, so pay attention, and as I said, that's the reason why it's very important for you to have the principle at the back of your mind and to read each sentence in relation to that principle, so that once a sentence supports the principle, you can end your reading. It is at this point that you can start writing, and trust me when I say that if you do this well, that from the beginning you were very relaxed, you didn't just start by writing anything, you had your principle at the back of your mind, and you were reading each sentence in the case in a very relaxed way with the principle at the back of your mind. Once you find the statement or the sentence that serves as an authority for your principle, immediately you start writing. It flows like magic. You remember the specific facts that relate to that principle, so you're able to put it down. I can reduce a fact that relates to the principle into 1 sentence, maximum 2 sentences, because I know that I don't have to write every single fact. I don't have to recollect every single holding. And I was paying attention, or I was entirely focused on the part of the statement or the part of whatever it is I was reading that relates to the principle. So once I hit the point where I feel like, bingo, I've gotten the statement that serves as an authority for the principle, then I can then write. If you do this well, you can write half a page as a brief for a case that is 10 pages or a case that is 11 pages. It's all about strategy and being able to pay attention to the things that truly matter. So now when you write this in future, you don't have to go back to read the case entirely. You have your brief in your own words. So now if you have to revise, you can always go back and look at your brief. You don't have to go back and read the 10-page case or 11-page case. So what I've said is simple. Relax, ensure that you are calm. Don't start by writing. Know the reason why you are reading the case and read every single sentence in the case in accordance with that principle for which reason you are reading the case. When you get to a point where you have found a sentence or a statement, and it's always like that, there's always a sentence or a statement you're looking for in the case that will serve as an authority. So when you find it, then you can start writing. It is at that point that you have briefed the case. And in future, you can always make reference to your briefed case. Another time, you read the case in relation to all the other plenty things that they said in the case. But at any given point in time, focus on the principle for which reason you are reading the case. Here's where we end today's video. I hope you found it educative. I'll see you again in another video. Bye.